But when I first met him, he was terrified. He had never been in trouble before. He cried when I spoke with him. He just said, how did I get here? How did this happen? The man that died was really his only friend that he had. We made the requests. We subpoenaed the detectives. We subpoenaed the crime scene officers to bring everything. And still, even the night before trial, we were getting new stuff. I mean, it was crazy.
I mean, we took the high road and we said, it's not their fault. They would never intentionally misrepresent something to you. They just didn't know.
The other friend who got pushed down, she's the one that had that machete. She never admitted to having the machete.
Exactly, and that's what happened. She gave us the things we needed her to give us. She gave us the fact she and our client had witnessed and had heard the domestic violence by the deceased on his girlfriend.
I really think that they did not answer the questions that probably the jury was asking in their minds, like, well, but there was a knife.
He used index cards and he said he wrote individually reasons for reasonable doubt. And then he said during this closing argument, he just fanned them out. They have to discount each and every one of these.
Yeah. They essentially said he killed an unarmed man. That is what I remember her saying in her closing argument. And it was just
not the facts.
There are times where I think the criminal justice system didn't get it right. And it just kind of renews my faith in jurors and the fact that they want to do the right thing. And we as advocates, we as attorneys, it's our job to explain to them why what we're saying is the right thing to do, why this is justice in this case.
Welcome to the Iron Gavel. I'm Chris Washington, a criminal defense and personal injury attorney with over 17 years of courtroom experience. Today we explore the gripping tale of self-defense by a gentle giant, Juan Ramos Escamilla. Is that right?
Escamilla in Texas.
Escamilla. So let's uncover the truth today. Today's guests are attorney Christy Jack and Carreras. Their client was facing a life sentence for murder. Christy is nationally recognized and has tried over 200 criminal cases before a jury. Her courtroom skills and expertise have led to appearances on 48 Hours, Dateline, Dr. Phil, Investigation Discovery, Cold Case, Forensic Files, Court TV, and Prosecuting Evil. You know what?
I said, I want everybody to know I did not write that.
That's great. Attorney Kara brings formal prosecutorial experience and she's also board certified in criminal defense. So she brings all this experience to every case she takes on. Before becoming a lawyer, Kara worked in the Dallas County Crime Lab. She also handled DNA testing and analysis. Furthermore, a part of her job included testing as a forensic biology expert in court. So now that we know the lawyers behind this victory, let's get straight to the case. Who wants to give me a 30,000-foot overview of this client and this case?
Well, I think the best person to do that would be Kara.
Well, so 30,000-foot overview. Mr. Ramos Escamilla was at his home late January 2023. And it was one of those weird nights in Texas that we rarely get. It was starting to snow and ice and sleet. And when that happens in the Dallas-Fort Worth area, everything kind of shuts down. And so everybody at that time was getting ready for this snowmageddon is what we call it. He and his wife were inviting friends over. They invited their friends over to have some pozole and some soup with them and just kind of get together, have drinks and, hang out. And they had done this a million times in the past. They had done this a lot of times before. And as the night progressed, I think Christy says it really well. They were dancing and getting together and the deceased basically was kind of agitated, acted weird, and kind of started just getting off kilter. Christy, you take it from there.
Okay, so they were all sitting around the kitchen table. They were all good friends up until that night. And so they were eating traditional Mexican food. They were drinking drinks. And our client Juan asked the wife of the deceased to dance. They got up and were dancing a traditional dance, and all of a sudden the deceased became enraged. So much so that he got up and he shoved his girlfriend, and she lost her footing and fell against the refrigerator, and everyone else stood up and couldn't understand why he became so upset out of the blue. And the deceased then pronounced to everyone, "We're leaving," and grabbed her to take her outside of the house. And there was a lot of words, there was a lot of anger, and principally everybody was trying to protect her. They were trying to protect her from him assaulting her, and they were trying to protect her from getting in the car with the deceased, who was clearly drunk. So they all go outside, and then what happens next kind of depends on who you're talking to. What is consistent is that the deceased assaults each of the women at different times. He assaults first his girlfriend in the kitchen, and then as the other women are trying to convince him to let her stay, he then shoves one of the other ladies. She falls to the ground in this icy weather that we're having, and he then continues to try to kind of manhandle his girlfriend to get her into a car to leave. So the skirmish is taking place in a driveway and in the front yard in very icy, kind of treacherous weather. So their voices are raised. The young lady that he pushes after his girlfriend reaches for her machete in her car. The deceased tries to get his machete in his car, and there's an argument outside. Our client and his wife are talking to each other, and she's trying to calm our client down as well, whenever the deceased lunges towards what amounts to be our client and his wife, okay? And depending on who you ask, it was either the deceased or our client that pushed the wife out of the way. And as the deceased is lunging towards our client, he stabbed one time about right here in his stomach.
He died within seconds. He fell to the floor and died.
So that was pretty intense. And ultimately, your client gets arrested, and then he comes to you guys. Tell the audience about the initial doubts and fears that he may have had, and some of the initial doubts and fears that you guys had.
So I was the one that had the case first, and I brought Christy on a little bit afterward. I went to her for some advice prior to his indictment. But when I first met him, he was terrified. He had never been in trouble before. He cried when I spoke with him. He just said, "How did I get here? How did this happen?" You know, the man that died was really his only friend that he had. He didn't go out and party. He hung out with his wife, and basically his wife's friends were his friends. And so this guy was dating his wife's friend. You know how you probably get dragged along to, your wife or significant others things too. So that's essentially what had happened. And he was devastated. He didn't know anything about the legal system. He's not originally from the United States. So I'm Puerto Rican. I speak Spanish. And so I often represent defendants who can't speak English and don't know anything about our system. And so just explaining the basic rights and what a jury trial is, because here in the United States, our jury trial system is so incredibly different than those in Mexico and Central and South America. And so it's really almost like educating and starting from scratch. He's certainly not a child, but that's kind of the way you're explaining how our system works to this individual who hasn't even been in trouble, anywhere that he's lived. So
I think it's great. I don't even want to assume this. Is there a shortage of attorneys in Texas to represent Spanish-speaking people?
Most definitely in our county.
It's probably 10 times worse here in Louisiana. Sometimes they struggle even to just get an interpreter to come help the lawyer who only speaks English to translate.
I can tell you what a blessing Kara is, because not only does she speak Spanish, but she truly cares about her clients. So Kara and I were good friends before all of this. And Kara had been telling our group of friends about this case. And of course, we all talk about our case. We're all criminal trial lawyers. We're all female. But there was something about this case for Kara that was special. She felt like this was a complete injustice, that he had not been treated fairly, that he should not have been charged. She believed very strongly that the case should have been no-billed at the grand jury. Now, I don't know what the criminal system is in Louisiana. But in Texas, every felony case, generally speaking, has to go in front of a grand jury. And at least 9 of the 12 people on the grand jury have to believe that the case should move forward. Kara had actually approached the district attorney's office and the prosecutor that was handling the case, which coincidentally happened to be the same lawyer that tried the case, which rarely happens. But Kara approached them and said, I really think this is a case of self-defense. I mean, our client had no choice. The deceased was lunging at him. His wife was in the way. There was only one stab wound. And the state disagreed. They disagreed vehemently. And they were just like, well, we just don't see it that way. We'll just have to agree to disagree. And so then they indicted the case, much to Kara's disappointment and really surprise, I think, because I think she rightfully believed the case should have died at the grand jury. Nevertheless, they indicted the case, and the state so strongly about the case that they put a 35-year offer on the case, which in our world, when you put a 35-year offer on a case, that means you want a trial. You think this is a good trial. You think that this is a very winnable case.
Now that we know the prosecution's viewpoint, essentially it sounds like they thought they had a slam dunk. So I want you guys to tell me about some of the problematic evidence you faced early on.
The number one, the most problematic issue was the fact that the deceased, everyone believed he was unarmed. They believed that he never had a weapon and that he did not have a weapon. And so that was really what I thought in the beginning, and which is why I brought Christy on. She is a mentor to me. She's a mentor to many lawyers, but certainly I respect her tremendously. And so I went to her and I said, what should I do? How should I handle this? And that's really how she stepped in and got involved, was at the grand jury level with me, helping me walk through it. But that was really the most problematic, I thought.
Obviously, that's the biggest issue because in Texas, in order to have self-defense in the instructions that the jury gets, there has to be some evidence that the deceased was either using or attempting to use deadly force. Without getting too much into the mud in terms of the law, I was really worried about what that evidence would be, how we make the argument that he was even attempting to use deadly force, because without evidence to that, the evidence can come in a lot of different forms. It can come in a lot of different forms, but you have to have some evidence to even be able to ask the judge to give the jury the law about self-defense and someone's right to defend themselves. And so that was a big issue coming into the trial because we thought we had a deceased. And I will tell you that the wound to the deceased penetrated quite a bit of distance. So it wasn't just a superficial wound. I mean, it went into the stomach. It pierced all the way back, really to around the spinal cord. It was quite a penetrating wound. There was also kind of a superficial cut right here. When you're looking at evidence, especially when you're looking at injuries, one of the things that you always want to be able to do is be able to explain how those injuries occurred in a way that is not harmful to your client. And the way that when we were meeting with the pathologist, the way that we looked at it was, well, perhaps when the deceased was falling, if our client was still holding his pocket knife on the deceased way down, his chin grazed the knife, as opposed to it being some separate slice move. Well, and then the other issue that we were able to use, I think, anytime you defend a case, you're not going to just have one defense because you never know what a juror is going to bite off on. You want to have a lot of different defenses going so that they might go, okay, well, I'm not 100% convinced of this, but I do think that. And with that one stab wound and the testimony that we really believed was going to be elicited and did, in fact, come out during trial, that the deceased lunged, our question for the pathologist, which I did not think ever occurred to the state, can you say, just looking at those injuries, whether the injury was sustained as a result of basically an affirmative act by our client with the knife? He said, no, I cannot say that. And I said, can you say, looking at those injuries, whether or not, in essence, when the deceased lunged, he basically impaled himself on our client's knife, or whether it was somewhere in the middle? And so, as you know, as a lawyer, that goes to the act, whether or not it was intentional, whether a lot of different kind of causation issues. And so that was, I think, somewhat of a surprise to the state when Kara was asking the pathologist that line of questions.
I talked to a lawyer in Detroit recently. He used index cards, and he said he wrote individually on index cards reasons for reasonable doubt. And then he said during this closing argument, he just fanned them out. They have to discount each and every one of these.
Yeah, absolutely.
It was brilliant. I said, wow.
Well, the really creative thing that Kara did in closing argument, and it was really funny because the judge that was presiding was a very senior retired judge. He was a visiting judge. But the courtroom was packed, and there were a lot of senior representatives from the district attorney's office. And in fact, some other district judges had come in to watch the closing arguments. And the law of self-defense in Texas is what is reasonable standing in the defendant's shoes. So what is reasonable standing in his shoes? So at the end of Kara's closing argument, she took his shoes off and put them right in front of the jury on the ground. And you could see the senior judge, this judge that's presiding of it, just going, you could tell she was like, what is she doing? And the district judge that was in the audience, one of them that called me after the trial when we got the verdict, said, I didn't know what y'all were getting ready to do. I didn't know what was fixing to happen, but he was like, I loved it. I loved it. But it really brings it home to a jury.
Let's rewind a little bit. As criminal defense lawyers, our case typically is built during cross-examination. So I want you guys to kind of go through some of the key prosecution witnesses and how y'all dealt with them on cross.
I guess we can start with one of the things that became important during the trial is a set of keys. It just appeared to be a set of keys. That's the only way it was referenced in the entire case, was a set of keys. And so the very first witness that the state put on the stand was the deceased family, the family that he had here, because he also had a wife and kids in El Salvador, and he had a girlfriend here. So we love putting a lot of women on the jury for that. So they put his, I can't remember if it's like a cousin on the stand to start out the trial. The keys were the keys to the deceased car. All right. We asked the family member on the stand, and you went to the police department after the fact. She goes, yes, ma'am. A few days later, you retrieved the keys. Yes. You took the keys home. Yes. They were the keys to the deceased car. Yes. The jury's just looking at us like, what in the world does this have to do with anything?
And that was it. Christy's like, thank you so much. No further questions. That was it.
And the state's just like, who cares about the keys? Yeah. And they're all just like, I'm sorry you have to be here. I'm so sorry for the demise of your loved one. Now let's talk about the keys. And so then they put on, I think the next witness is like the patrol officer. Is that right, Kara? Vega?
They had a couple witnesses after that, but later on they put on the patrol officer that showed up at the scene immediately following. And it was like a mic drop moment when Christy cross-examined that patrol officer.
Give it to us right here, Christy. I want to hear it.
Some people think cross-examination has to be mean, that you have to just go for the jugular. And sometimes there is a time that you have to do that, okay? But then there's also times, and I find really the more effective cross-examination is when you very politely get to the point that turns the case around and you make the state's witness your witness. And so the state put on this witness. He's a patrol officer. He happened to be among the first officers to the scene. Now, when the deceased is on the ground, you have MedStar get there. They're trying to save his life after the police have tried to save his life. You really see the best of humanity, people trying to save someone's life. That was this officer. He was a former Marine. He was very professional, had done an exceptional report. We have an issue in Texas with police officers, even though they're wearing body cams, turning them off at critical times during an investigation. He did not do that. And we used him as a contrast to another officer later on. You know that you're supposed to keep your microphone on, and it's really designed for two things. Number one, and most importantly, perhaps, and I go, it protects you from false allegations. And he was like, oh, yes, it does. And I said, but number two, it protects the integrity of the interview with witnesses and of the case as you're out there on the scene. We don't have to wait for you to write down something in the report. We see it happen in real time. He's like, yes, ma'am. And of course, he's always a good witness when they say, yes, ma'am. And he's a former Marine and had a good little sense of humor. And so mind you, these keys that have still been mentioned as keys throughout the report. I have his body cam, and I have him on a couple of other officers' body cam. And I said, now, officer, I said, you're looking for things out of the scene. Do you know it's evidence? And he's like, no, ma'am, I don't. So I try to pick up everything. And I said, okay. So you mentioned looking for some keys that were found near the deceased body, like within inches away. He goes, yes, ma'am. And I go, what was important about that? And he goes, well, you never know. It could have been evidence. And I said, in fact, you mentioned something on those keys. And he was like, yes, ma'am. And I go, a knife, wasn't it? And he was like, yes, ma'am. And the state was just like,
my question, what was the prosecutor's response to that?
There's no way they knew because they didn't mention it in opening statement. I mean, that's the kind of fact that if you're the prosecution, you get in front of it and you explain why that individual is still guilty in spite of that. There is nothing about that trial that suggested they knew that.
I want to interject about that because a lot of times cases are won and lost based on the level of detail we as lawyers give to reviewing the evidence. So I want you guys to kind of briefly touch on, because you had to watch video and read reports and compare and contrast to realize that this was omitted from that report. Like, this should have been in there, that there was a knife on these keys. So just kind of take me through why you don't simply rely on a police report and why you scrutinize and review every piece of evidence.
Our review and what we did turned this case around. It just did. And Christy always says, you know, I may not be the smartest one in the room, but I'm going to be the most prepared person in this room. So in this situation, I requested, you know, this discovery. We have here in Texas the Michael Morton Act, where they have to give us every single thing. I mean, detective notes, everything. And so we made the requests. We subpoenaed the detectives. We subpoenaed the crime scene officers to bring everything. And still, even the night before trial, we were getting new stuff. I mean, it was crazy.
Oh, during the trial, you guys are getting stuff. During jury selection, more evidence.
Yes.
Oh,
Yes.
wow. That is not typical, right? It shouldn't happen, but it happens way more than it should. Let's say that.
A couple of weekends before trial, we went to her house. This one Saturday, we just said, you know what? Let's spend all day looking at all this body cam. And so we're just scrolling through the body cam, hanging out, drinking our coffee. And Christy goes, I'm going to run to the restroom real quick. I'll be right back. She gets up, just stands up from her chair, and you hear the officer go, hey, Officer so-and-so, where are those keys that had the knife on them? And she and I both just jaw dropped. We had been watching this body cam since 8 in the morning.
It's like watching paint dry, too. It's not like it's exciting.
I literally stand up when he says something, knife. And I go, did he just say knife? And she goes, yes, he did.
We had already looked at a bunch of other body cam that had no audio. And so then we had to go back to some of those body cams and go, okay, wait a minute. Is he in that body cam? Where are the keys? Where did they end up? We're calling our client's wife if she knew anything, because she was there the whole time. It was a very chaotic scene because the deceased was there. The girlfriend was screaming just like crazy on top of him, and they were trying to remove her. And sure enough, we found another body cam that had no audio on it, but it was that amazing patrol officer that kept his body cam on. He finally found the keys. He's got a glove and he's holding the keys, and he just kind of lifts it up almost just like this. And you see this big pocket knife
that you kind of get at gas stations along the interstate.
Yeah, it's not like the little Boy Scout knife. It's like a curved knife. You could probably use it to skin something if you wanted to, but it was enough of a knife.
And so we got a computer expert to do a slow-mo video, do an HD, zoom in on it. And we had that ready to go.
When I had the little Marine officer come down in front of the jury and ask him to show the jury, I was like, tell the jury what this is. I was just showing the picture, and Kara was watching the jury.
Why did you call him off the stand instead of just letting him explain from his seat?
Outside of the judge, I was the oldest attorney involved in that case, which I'm fine with. But I'm old school, okay? I like to have my notebooks in paper, okay? I like to write things on notes. And I feel like in this day and age, with things on the digital screen, on computers, on PowerPoint, it kind of removes the jury from engaging in the case. And so I like to have a mix of things, but I'm old school. So I like for my witnesses, especially when it's a state's witness I've turned into my witness, to get down there and be about a foot away from the jury, so you can be deferential and say, and show it to each single juror and make sure they can each see it, because you're also showing the jury, I care that you see this evidence. Do you see how important this evidence is? And I want to make sure each of the 12 of you see this. You could see the jurors just kind of nod when they'd seen it enough. And so it goes with each juror. And, we can't talk to jurors, but that's about the closest thing I can do.
I do that too. I always tell people we call it putting it in action. I did some TLC stuff where we did psychodrama and that sort of thing. So reenact or relive the moment in the courtroom is always going to be more powerful than just words. Honestly, if we just kind of have the witness blur it all out on the stand, the jury's going to miss half of it. But if we can kind of slow it down and take those moments to relive it with them, I think it creates a lasting impact and impression on their mind, really, that you just can't get with words only.
Right. Well, and it also kind of made them look like the state was not being forthcoming or did not know their case. One of the two. I don't know which one it was. I mean, we took the high road and we said, it's not their fault. They would never intentionally misrepresent something to you. They just didn't know.
That's great. I like that. There's a lot of cases that go to trial because the prosecutors, either they don't have time or they just don't take time to review them thoroughly.
And evaluate it.
Yeah. Now that all this comes out in trial about the deceased having a knife, and the prosecutor obviously not mentioning it in his or her opening statement, what do they do in closing argument?
Well, before we get there, if you don't mind, Kara had done an amazing job with some of the other state's witnesses, and she had all this information that we were able to elicit that the state also did not know about, like the girlfriend, like the wife.
Let's hear it, Kara. Tell me about the girlfriend and then the wife.
The deceased had a machete in the back of his car. One of the female witnesses brought her machete out in the middle of this, banged it on the front of somebody's car, and that kind of got the deceased even more angry. And then there was another machete that was around the corner, not even part of this, but somehow the officers go find this machete that's completely not even related. They bring that into it. We elicited a lot of information. For instance, my client's wife, she said she was the one that was like, we lived with them. We knew the deceased. He was violent. We could hear next door when we lived in the room with them. He was violent with his girlfriend. They often got into these fights and arguments, and you could hear pushing and shoving and things like that. And our client, Juan, would say, look, it's not our deal. We're not getting involved. He just didn't want to cause fights. He didn't want to cause problems. So that was one thing that we were able to elicit. Also, the deceased girlfriend and our client's wife, they were friends, and they had, the week prior to this, they were at a quinceañera together with the deceased. And we learned that there was an altercation or argument that involved the deceased and someone else at the quinceañera. And during this quinceañera, somebody's cell phone was stolen at their table, like a friend of the deceased, her cell phone was stolen. And so the deceased got so enraged and angry about this cell phone, we were able to elicit from both his girlfriend and our client's wife during testimony that he actually went out to his vehicle, retrieved his machete, stuck it down his pants, and was like walking back into the quinceañera over a cell phone being stolen that he thought somebody stole. I mean, that's how volatile this guy was. Like Christy said earlier, that was a really important point for us to get out because it showed our client had knowledge about that. His wife said, I told Juan about that incident. He knew about that incident. And so I think that shows our client's state of mind in knowing what the deceased was like. He was quick to anger. Those were just some interesting cross-examinations that set those witnesses, I think.
Anecdotal character evidence as to the deceased. And in addition to that, so this took place January the 31st, 2023. And so at a Christmas party in December, wasn't it the Christmas party, Kara?
Yes, that's right. It was a Christmas party on Christmas Eve. They had a Christmas party at their house. Yeah.
The deceased had shoved our client's wife, and our client went up to the deceased at that party because the wife said, please don't do anything. Please don't get involved. And so he just went up to him and said, don't ever lay your hands on my wife again. Okay. So in Texas, in terms of real danger and what's called apparent danger, part of what you have to do is you have to elicit this testimony to establish why you're entitled to the defense involving real danger and apparent danger as well. And so these were all stories, anecdotal evidence that we had that the state had no knowledge of, really because they didn't ask the right questions. I've always said, you don't ask the right question, you're not going to get the right answer.
I know you guys describe Juan as the gentle giant. Why is that?
So I've been texting with him today and over the last couple of days. He and I are still in contact. After the jury verdict, the jurors actually used those words, that he looked and seemed like a gentle giant. They said that to us. He's about 6'3". I think when this happened, he was probably, well over 300 pounds. By the time this was all done, he was a little less than that, but a big guy, heavy set guy, 6'3". And in our defense, that was on our fear list, that the deceased is like 5'5". He's a little guy. And so that was something I think that was also on our fear list the entire time. And he never wanted to argue. We were able to elicit testimony that he stood back and let this fight happen. He never got involved in any of that, even that night. He's just kind of a guy that's real calm and cool. He laughs a lot.
The other thing that showed how reluctant he was to engage in confrontations, he testified. And we told him that we thought he needed to testify for us to win this case. And he's just very reticent, very reluctant to express himself. And so Kara was questioning him, and it was like she was having to literally just pull the words out of his mouth. Now, mind you, he's testifying in Spanish. It's being translated to English. It was a lengthy process. And I remember at lunch, we took a break. I had to go back there with the translator because I'm not fluent or bilingual by any stretch. Maybe when I've had a margarita. I had to go back in the back with the translator and say, las palabras, the words have to come from your mouth. I said, Kara can't speak it for you. You have to tell the jury how scared you were. He was almost wringing his hands. It was so hard for him, for something we all take for granted because this is what we do for a living. But it was so hard for him to articulate and express how scared he was, how upsetting it was. Even just watching the autopsy when the pathologist testified, he just broke down in tears because this was his friend. But yes, he had to get a pep talk in the middle of his testimony.
Men tend to have this macho man, I'm not afraid of anything. It's not true. As I tell my boys all the time, a man crying is not a sign of weakness. It's like you can just let it out. And I actually have 6 boys and a girl.
I didn't have time for a podcast.
They're at school. They'll be coming in shortly. You don't always have to be tough and macho. I think men struggle more emotionally a lot of times because we keep it all bottled up, and we shouldn't. I'm glad y'all got Juan through that. That's what I always tell people. Our profession, we're so much different than everybody else because we go to law school and learn law. And then when you get out of law school, you're like, oh crap, I need to learn medicine, psychology, psychiatry. So many different disciplines we have to learn on our own because there's no more schooling really after law school.
But that's what makes criminal law so fun.
Yeah, every case is different. Any other witnesses we need to hear about, Kara?
We had Lisa, our client's wife. We had Juan. We had the deceased girlfriend. And then we had the other friend who got pushed down. She's the one that had that machete. She never admitted to having the machete. She lied that she never had the machete. But in fact, every other witness said, yes, she had this machete out. And the state supported that witness.
I didn't think you're put a witness on the stand if you believe they're going to commit perjury. But we had that as well. And then the state called our client's wife thinking she would invoke her spousal privilege. And she goes, nope. I was like, what are they doing?
How did that go? Because it blew up in their face from the start. So I want to hear what happened.
That was very interesting. So our client's wife, at the time of indictment, I said, hey, my client's wife is willing to testify. She's the only one that actually told the truth at the scene. During the indictment process, the state never called her. They called all these other witnesses, the other female witnesses, who told a different story. Again, so they had told a couple of different stories. So by the time we get 2 years down the road and we're at trial, the state really wants to talk to our client's wife. And our client's wife was like, no way. Y'all's chance to talk to me was 2 years ago, and you're not here to help my husband, and I'm not talking to y'all. And so they sat up on her house. I don't know how many weeks, Christy? A month. They sat up on her house and were just looking for her. Anyway, so they finally ended up subpoenaing her and brought her to court. And I went up there with her. She wanted me to go. So I went up there and they said, hey, can we talk to you? And she's like, nope, I'm not talking to you. And so the day they wanted her to testify, they brought her in and they said, you know, we just want to know if you're going to waive your spousal privilege. And she said, yes, I am going to. And they were like, okay.
Okay, so time out. So in Texas, if someone invokes their spousal privilege, the jury's entitled to know that, and you're entitled to comment on that. I think the state wanted to use that to bolster or to buttress their argument that she knew the truth. She knew this wasn't self-defense, and that's why she didn't testify. But the real shock was when she said, I'm waiving my privilege, that they called her because they had no reason to believe she was going to help them. And she didn't.
Because, you know, she wasn't perfect for us. You know, we had some concerns. We hadn't planned on calling her because of those concerns. But ultimately, she didn't give us everything we wanted. But she also, I think she was extremely truthful. You know, she said her story and that hers was the only one that really never changed from the beginning.
Now, I will tell you some inside baseball. So, you know, as trial lawyers, which is another reason why I don't like technology, because technology breaks. Or you forget a password, or something else. And I am very tedious about my trial outlines. I make a whole outline of every witness, what I'm going to cross them on, or what I'm going to direct examine them on. And so I have this outline, and I looked at it before we got on this podcast, and I think it was like 45 pages, and that wasn't even the last one. And so I have this outline of what I'm going to question her on if the state calls her. Well, of course, my computer craps out and I can't even get into my computer. And so I've got one of the younger attorneys sitting behind me, my associate. She's like, what are you going to do? And I'm like, I'm going to go old school. Believe it or not, we used to try cases before technology. And I said, and besides that, I know the story I'm going to make her tell. So.
One of the guys I interviewed recently, we were talking about the same thing. When I getting ready for trial, I write out my cross-examination. And he said he did the same thing. And then what really happens too, part of it becomes muscle memory. Once you write it all out, it's kind of there. You don't like live through the outline. It's really a security blanket because if you've learned your case and you've written it out, it's kind of all in your head.
Exactly. And that's what happened. You know, she gave us the things we needed her to give us. She gave us the fact she and our client had witnessed and had heard the domestic violence by the deceased on his girlfriend. She gave us the quinceañera where the deceased had armed himself with a machete over a cell phone. She gave us the Christmas party where the deceased had shoved her. And so this was the state's witness, and it just, in my estimation, torpedoed their case.
A lot of people, lawyers, would say you guys violated an unwritten rule to never put your client on the stand. I sincerely believe that in most self-defense cases, the jury expects to hear from the client. So what factored into you guys' decision that to get to the point where you're like, hey, Juan, you're going to have to testify in this trial?
We really struggled over that, and we kept thinking, well, wait, maybe we can call Lisa, his wife, to prevent from him having to be called. And we ultimately decided they were going to have to hear from what his frame of mind was in those moments. I don't think there was any other way that we were going to get that out. And we almost didn't get it out even with him on the stand. I mean, thanks to Christy.
Sometimes that's necessary, I can tell you from experience. We get to the prosecutor's closing argument. Now, how do they deal with the fact that they didn't know about the keys with the knife, or at least they didn't mention it in opening? They called the client's wife and it blew up on them. and then the client testified and he did well. How did they deal with that in their closing, and what was you guys' response to it?
I think that they had difficulty pivoting. I really think that they did not answer the questions that probably the jury was asking in their minds, like, well, but there was a knife. They essentially said he killed an unarmed man. That is what I remember her saying in her closing argument. And it was just
not the facts.
Right. And I got to go after her. And I was like, I'm not sure what trial they were sitting in.
You got to go after her? You guys both got to make an argument during closing?
Yeah. So in Texas, the state has the right to go first and last. And I believe the judge gave us either 30 or 40 minutes aside. So what most defense attorneys do, well, the state will go first. Their job is basically to just lay out generally the facts and go over the instructions that the jury has. And really, there was a lot to it because the jury received murder, manslaughter, and criminally negligent homicide. And you have the right to defend yourself against real danger and apparent danger, which you reasonably believe, which goes into all of the history that he knew about the deceased and how violent he was. So you go over the instructions and then you go over the facts. And so she went first, and then I got to follow her, and I argued for 15 or 20 minutes, and then Kara came behind me, and then the state came behind Kara.
Ah, gotcha.
They get the final say, and in her final say, just telling the jury that the deceased was unarmed when they saw for their own eyes on a piece of evidence that he was.
I tell people all the time, as great of an argument as a lawyer might be able to make, if there's video that contradicts it, the jury's going to listen to the video.
Right. They're going to trust their own eyes. It's easier to take the high road to say they just didn't know about that knife as opposed to they lied to you. At the beginning, I just don't understand why they said he was unarmed. I mean, his knife was the same size or larger than our client's knife. And so if he's unarmed, so is our client.
I think you guys' strategy is probably something a lot of young lawyers can take away. Because a lot of young lawyers think every trial has to be a fight. Like, these prosecutors lied, or they knew about this knife and tried to hide it. First of all, you can turn the jury off with that. And second of all, you guys realize that, hey, that's not necessary. It's perfectly fine to say, look, we're here because they missed it.
And it's more palatable for a jury, because they might think if you sit there and you say they lied, a jury might sit there and say, well, I have to believe they lied to find him not guilty. And that's just not the case.
People want to believe our system is flawless. They want to believe police officers don't lie. They want to believe prosecutors don't cheat. And if you can make the same powerful argument or even a more powerful one by not attacking them, and maybe it's a lack of training, a lack of preparation, all of these things can take you a lot further than just accusing somebody of doing something that you can never fully prove,
And that's off-putting to a jury, I find. I think as a general rule, most prosecutors do what they think is right. They're hardworking, they're underpaid, and they try to do what is right. And if a mistake is made, it's generally an oversight. It's a mistake at that.
I agree. So tell us about the moment the verdict is read. I want to know your client's response, his wife, his family, and you guys' response.
I became very emotional. I love all of my clients. I work hard for all my clients, but I feel like we felt a lot of pressure in this one because the more we got into it and the more Christy and I worked on it, the more I felt we were right and that it would have been just a terrible injustice, had he been convicted of murder. He wept. And we all just cried. I cried. I think Christy cried.
I don't cry. I'm not crying. You're crying.
I represented a 17-year-old accused of 3 counts of attempted murder. And he was so tiny that I just knew if this kid would have gone to prison, he would not have done well. And look, I shed tears when he was found not guilty.
I think verdicts like this one in particular, restore the times, and it's not very often. There are times where I think the criminal justice system didn't get it right. Not necessarily in my cases, but I see other cases. And it just kind of renews my faith in jurors and the fact that they want to do the right thing. And we as advocates, we as attorneys, it's our job to explain to them why what we're saying is the right thing to do, why this is justice in this case. It doesn't have to be justice in every case. We're not making some blanket assertion about all cases. But in this case, Juan Escamilla was entitled to defend himself, to defend his life, and to defend his wife's life.
Kara, you said something earlier, and I think I know why, but the audience may not. Earlier you said you were just texting Juan earlier today. When the case ends, why don't you tell a client, it was nice meeting you, good to know you, let me know if you ever need me again. Why do you keep in contact with them?
That's usually what I do. Usually I'm like, bye. Sometimes I'm like, thank goodness this is over, But Juan, he's likable, he's lovable, he's a good person. And, when I talked to him today, in fact, I was looking at my text that he sent me. He is so grateful for me and Christy. He's like, I could have gotten any other lawyers. He told me this today. He goes, this was my friend. Never would I have ever wanted to do anything or have anything like this, happen. And it was so traumatic for me, for everyone, for his family. He's still living through what happened. He gets to be back with his family. His father died right before he was able to see him. And so he didn't get to see his dad before he died. He just really holds a special place for me.
I sincerely believe that most lawyers who do well doing criminal defense, first of all, you have to care. And a lot of us end up being friends with our clients. The first person I ever interviewed on this podcast was a former client. He comes to my house when I have crawfish balls. We've met up in New Orleans to hang out. He was a former police officer charged with armed robbery, which carries up to 99 years in prison in Louisiana. And we went to trial and he was found not guilty. But Anton and I have remained close, and this was over 10 years ago.
That's wonderful.
This was great. You guys were the first time I interviewed two people at once, so I was scratching my head, but I think it went well.
Please let us know when this airs. We'd love to watch it.
I will do. So before we go, one final question. If somebody is in you guys' area, how do they connect with you? If you need a criminal defense lawyer, how do you reach Christy? How do you reach Carreras?
The law firm that I work for is called Varghese Somerset. That's VARGHESE SUMMERSETT, and I'm a partner here. And our phone number is 817-203-2220, or you can just look up Christy Jack, and you can find me on the internet.
So I am Carreras, and I have my own private practice, Carreras Law Group. I have an office in Fort Worth and Dallas. And you can call or text me, 817-795-9956. So we're here, ready to serve.
Great. Thank you, ladies. And we made it in an hour. I actually like the pace. You guys kind of pushed me. I like the pace. I'm going to compare it to some of the other ones where I go slower. But I actually enjoyed this pace because we were able to add the emotional impact of, Juan's experience or this case's experience.
Well, thank you very much for inviting us.
Thank y'all. When it releases, what I do is I usually get an intro video on a Monday and I'll send it to you guys, and then the episode itself will be released on a Friday.
Okay, great.
All right.
Thank you, Chris.
All right, thank y'all. All right. Y'all take care.